Volunteers and clubs are a valuable asset to SDSU Extension and by association are considered an arm of Extension. Any organization associated with SDSU Extension must adhere to all SDSU civil rights policies. Club members, officers, leaders, and volunteers must understand the value of diversity and the expectations for equal opportunity requirements. Equal opportunity requirements apply to any setting where clubs meet collectively within a county, region, state, or nationally. The membership of all clubs operating in interracial and non-interracial communities must be open to all individuals regardless of race and gender. It is the policy of SDSU Extension to comply with Federal Law Title IX, which prohibits discrimination against individuals on the basis of gender. Title IX prohibits sex discrimination, including sexual harassment. Sexual harassment can be in various forms. A serious form of sexual harassment is sexual violence. Sexual violence includes sexual assault, rape, battery, sexual coercion, and all forms of domestic violence. Another form of sexual harassment is quid pro quo, and occurs whenever anyone in authority misuses his or her power to coerce sexual favors. Other behaviors that could be considered harassment include sharing sexually explicit or offensive jokes, making suggestive or offensive comments, or touching someone on any part of their body. Harassment on any grounds is strictly prohibited. SDSU Extension offers access to its programs and activities without discrimination based on sex, race, color, creed, national origin, ancestry, citizenship, gender, gender identification, transgender, sexual orientation, religion, age, disability, genetic information, veteran status, or any other status that may become protected under law against discrimination. Harassment is a form of discrimination and is not permitted. Individuals with concerns or who want to file a complaint should contact the SDSU Title IX Equal Opportunity Coordinator in the University Office of Human Resources at 605-688-4128. Consider for a moment the consequences of this actual discrimination case that began in 1992 in Monroe County, Georgia. Fifth grader LaShonda Davis accused a classmate of using vulgar language toward her and attempting to fondle and touch her multiple times during a 5-month period. LaShonda repeatedly reported the acts of harassment to her teachers, but no disciplinary action was taken. LaShonda's mother brought a lawsuit under Title IX, naming the Monroe County Board of Education and several officials as respondents. Both a district court and an appeals court rejected the lawsuit, which was based on student-on-student sexual harassment. However, in 1999, the U.S. Supreme Court overturned the appeals court and held that the school board was liable. So, what does this mean for volunteers or clubs? It makes clear that even though officials may not themselves commit acts of harassment, they can be held liable. In this case, the Supreme Court found that LaShonda was deprived of the educational opportunities or benefits provided by the school, and that the school did not take meaningful action to prevent the harassment from continuing. It's pretty easy to imagine something like this happening with any activity or event. So if you witness any form of discrimination, please take the appropriate action to prevent it from continuing. Thank you for adhering to all SDSU civil rights policies. You are a valuable asset to SDSU Extension.